Welcome to another presentation for ViewMedi. I'm Jeff Segal, founder and CEO of Medical Justice. Uh, for over 2 decades, we've been helping physicians with a collection of medical legal problems, including frivolous medical malpractice lawsuits, problems with the Board of Medicine and National Practitioner Data Bank, issues with your hospital, and on and on. By way of background, I practiced as a neurosurgeon for approximately a decade, and I ultimately became an attorney, going over to what some people would say the dark side. But since I defend physicians, I don't think I went over to the dark side. Anyway, let's dive in. The topic for today is when your partner's legal trouble becomes your legal trouble. And I honestly don't know if I got all the parentheses, not parentheses, but apostrophes right in here. I will report back at some point if, for you grammar mavens, whether I did it properly. All right. So lots of people, lots of physicians, lots of healthcare professionals practice in groups. Why? Because and when I'm using the word partner here, I'm talking not so much as a legal description, but more as a group practice. And there are benefits to being part of a group. Certainly, you get economies of scale, you can get call coverage, you can get shared office space. The list is quite large, but while the benefits go up, so do the attendant risk. If you share a single tax ID, if you share a group provider number, if you share a brand and contracts, if one person creates a very visible catastrophe for your practice, there certainly can be spillover risk. So today's goal is to try to define what some of these risks are and see if there are ways to mitigate them. You will not get rid of them entirely because while people join groups for a reason, and part of it is for the benefits. And the only way to get rid of all of the risk is to get rid of most of the benefits. So the question here today is to make an informed decision as to what type of group you want to have and how to mitigate some of the risk if you can do it. So buckle up. All right. So what are some of the challenges that one individual can cause for a larger group? Well, if you're a multi-physician practice and one partner gets flagged for an insurance fraud, that's not good because what's going to happen is that everyone in your group likely will be put under payer review pretty quickly, and this may make it more challenging for your referrals to be seen properly. And those who were not even alleged to have created the problem with fraud, there will be collateral damage, even though they did absolutely nothing. So you don't have to actually be the individual being directly scrutinized to be part of a group that has collateral associated damage. All right. So these are some of the challenges. These are the things that people can share in a group. You share a tax ID. You can share a group national provider number, a CLIA lab number. You may have a facility drug enforcement number. Your contracts with various payers and vendors may be, one entity, maybe the group entity, and then of course your brand, your website, the sign in front, social media, um, billing, bank records. It's a pretty sizable list of the things that you share. I mean, once you become a partner, in a sense, you've become married. And so, you know, you're not dating any longer. You really have entered into a long-term relationship. All right, so different facts, same headline, but your group name is what is on page one. Happens with billing fraud and kickbacks, diversion with controlled substances. It doesn't mean that you actually created a problem, but all it takes is one individual to be rather generous with prescribing Vicodin well above the norms for the rest of the group for everyone to get taken down. Harassment or a hostile work environment where one person's got a temper or rather touchy, and everybody gets hit, with the same problem because the argument will be that it was tolerated, that this type of behavior was visible and seen by everyone else in the practice, and they just looked away. They took no action. So even though the rest of the group, not the guilty party, you've got the guilt by association. And then boundary violations, one physician decides to date a nurse or a radiology tech or whoever, and that they break up, predictably it becomes a bigger problem. If everybody knew about it and took no action, or at least didn't bring it up, this could be a challenge. And then, of course, off-duty criminal issues. Doctor gets into a DUI, for example, runs into a building, or someone else is killed, for example. Everybody's going to be part of that headline. All right, so you want to know more about the people coming in, groups. If you're joining a group, you should expect to be scrutinized. If you're in a group and you're trying to bring in new people, you should scrutinize them. How do you do it? The traditional way. You do it with a background check, looking for any criminal, civil, or any licensure problems. Um, you certainly have an obligation to query the National Practitioner Data Bank, um, and whether there's been any public order from the Board of Medicine. You definitely need to and want to ask about any hospital actions, as well as any payer terminations. A lot of this will be in the National Practitioner Data Bank. So you should ask the question and see whether the new person coming into practice is forthcoming on these details. But to the extent that you have access to the National Practitioner Data Bank, and the way you would do it is that for a large group to have access to the data bank, you need to have some type of internal peer review and due process mechanism. A three-person practice is not going to have um, access to the data bank, but you can certainly ask a new or prospective employee to have them do their own self-query and to show it to you. I don't think there's anything wrong with that. You want to know what is out there, and you want to see whether it jives with what they've told you. Public footprint, is the doctor in the news? Courts are public record. Sometimes it's easier to take a look. Sometimes it's much more difficult. Certainly, social media is a way to get a better feel for the public persona. If you're looking at it, the public will be looking at it. And I think you want a decent idea. If it turns out that your new hire is very famous for, their stance on clothing optional camping, and they've got websites associated with that. Not that it's against the law, but it's the type of thing that could injure the brand. You should at least be aware of it and make an informed decision. And then see whether there is any financial challenges. Has the doctor filed for bankruptcy? Are there any liens or judgments against them? Are there any public records of tax issues? These are issues that will manifest themselves down the road. It's helpful to be aware of it. Certainly, a doctor, virtually all of us should have some expectation of privacy, but because so many things are public now, there are ways to gather information, at least public information, without stepping on the toes of the employment lawyers, who will tell you the types of questions you can and can't ask. And I think that's a fine line. There are certainly some things that you cannot ask, but much of what I've described right here is public record, and you certainly have an obligation to review the public record. All right. Trying to manage separation if there's a problem. What happens if there's a problem and you're trying to, divorce very, very gently? Well, if everybody's using their individual national provider ID, then it's not gonna, there's no group NPI problem. That's not always practical going in. There are reasons to have a group NPI. So I bring this up more for education than as guidance or advice. Um, Distinct bank accounts and credit card accounts. If all you're doing is sharing common office space, and you're not really commingling anything else, there's no reason to have a common bank account. I would argue that you should have your own distinct bank accounts if you're just leasing space from each other and you don't really share much else. I mean, there certainly are entities where there's a common brand, but financially they are separate entities. And if that's true, you probably do need to have separate bank accounts, separate credit card accounts. Things that you want to own individually, if indeed they are part of your individual record, would be phone numbers, domains, social handles. But again, if you're only sharing space, those are the things you want to own. If you've decided to jump in and get married and be part of a group, then you're going to have these common assets, but you need to define what happens. If there's a divorce, who gets the phone numbers, who gets the domain, who gets the social media accounts. And then finally, DEA. Should you have an individual um, DEA number that you use? Should it be a group DEA? These are the types of questions you need to answer before there's a problem. And I'm adding on here the chaperone and boundary policy. Um, the time to put these into place is before there's a problem. And I'm generally a believer that it's probably helpful to have chaperones, certainly on examinations of intimate body parts, or evaluations of patients of the opposite sex. Um, One of the pearls that a expert witness gave to me was it's not even enough to just have a chaperone there. They should put into the record um, that they were the chaperone during the entirety of the examination on, Mrs. Jones on this particular date. They were there from the beginning to the end, and Dr. Segal comported himself professionally during the entire examination. That is a great note from his perspective, and having heard the types of cases he's defended, I totally agree. I think that's a great note to have, particularly when 4 years later, the chaperone has moved on. You can't, get them to testify what they saw. You just know that they were there. Maybe they left on bad terms and they've got an axe to grind. So getting this all squared away in the record at contemporaneously can only help, cannot hurt. All right, the operating agreement, your bylaws define what triggers problems down the road, how to manage them. And it's helpful to identify the cause. We call them for cause triggers, to potentially terminate the relationship. So if a doctor is indicted criminally, if there's a summary suspension of their hospital privileges, if there's an action by the Board of Medicine, an adverse action associated with public discipline, payer termination for misconduct, so on and so forth. All of these things can be tied to a for cause trigger, which might mean an immediate suspension. It may mean holding back their pay while an investigation occurs. It may mean limiting their access to the medical records or to the premises. It should be in the documents so everybody will understand what the playbook holds. Um, Also, if it turns out that this is going to turn into a divorce, if it makes sense to terminate the relationship to salvage the reputation of the organization, and you've already put this into the bylaws or the operating agreement, then you need to define how you buy them out. Do you buy them out at fair market value? If so, how is that determined? Do you buy them out at book value? Again, if so, how is that determined? Um, if it turns out that the individual doctor cost the practice additional sums that are well defined, is there potential clawback for these liabilities so that the practice can be made whole? The more this is put into the operating agreement, the less likely it is subject to interpretation or defense down the road. And also, there should be a mandatory cooperation clause, particularly if there are the the challenging issues of audit, subpoenas, or board inquiries. So, I mean, most people will cooperate, but if there's bad blood, you can certainly see why the doctor may conclude if I'm going down, everybody's going down. All right. So, again, what are some of these things that can mitigate the risk for you? So, having your own professional liability and making sure the professional liability gives you the type of coverage that you want. The coverage that I like to see is consent to settle, meaning that you must provide your consent for a carrier to settle the case. If it's not stated and the group just has a broad insurance policy, it may give the carrier the right to settle or the group the right to settle for that matter without the individual doctor. So if you are the doctor coming in, you want to at least know the type of professional liability that you have. What are the terms? You may not have the ability to make any changes, but at least be aware of what the policy reads. The time to make any updates or changes, if it's possible, or to supplement what you have, is on the way going in. And I think everybody should understand with their broker, the professional liability carrier, what may trigger non-coverage. If you've got 10 people in your group and one person is criminally indicted for some healthcare fraud issue, I think you should understand, will there still be coverage for the rest of the group, or does one person create a general problem for the entire policy? Obviously, you would want to make sure that if you can distance yourself from the offending individual, the rest of the group shouldn't be penalized, but you want to make sure that's actually in the insurance policy. Other types of insurance to have, something called EPLI, Employment Practice Liability Insurance. I want to pause for a moment because this is extremely important. I have it for our business. I don't know how many doctors have EPLI. I'm going to guess it's under 10%. I don't think the number is high. Why do I say that? It's because we get calls frequently about practices being sued by staff that formerly work for them, alleging sexual harassment, um, or age discrimination or other types of discrimination. I said, well, you do have EPLI. What's that? Employment Practice Liability Insurance. That tells me they don't have it. And these are policies that typically give you $1 million worth of coverage. And there's often a small deductible. It's not much. It's usually $5,000 to $10,000. But if you have to hire an employment defense attorney on your own, even if you win, your legal bills can easily get to $70,000, $80,000, $150,000. Then if you do lose, or if you have to settle a claim, the number can be quite staggering. EPLI is not that expensive. It's actually one of the cheaper insurance policies. I'm a big fan of it. So if you learn nothing else from this presentation today, see if you have EPLI. If you don't get it, or talk to your broker about it. This is the one thing that often gets missed, but wonderful to have. Um, Moving over, cyber insurance, again, also important to have. I think there's more awareness today of the need for cyber liability coverage. Um, it's helpful to have a seasoned healthcare insurance broker vet the proper cyber insurance for your practice, because these policies can be 100 pages long. They're very difficult to decipher, even for those in the industry. So having a knowledgeable agent makes a lot of sense. It makes even more sense because if they sell you the wrong policy, well aware of what your issues are, you can at least bring them into um, your evolving problem. A broker should have given you delivered their full professionalism, and they are held to a standard of care also. Director and officer coverage related to fights over governance, injunctions, etc. These are for the larger groups. For a two-person group, do you need three-person group? Do you need D&O coverage? I don't know that you do, but as the group gets bigger and bigger, and as there are issues or concerns related to governance, who's in charge of the organization, I think if you want somebody to step up and be in charge of some domain, you have an obligation to cover them for the liability associated with that. So D&O coverage. Unfortunately, D&O coverage is likely pricier than the EPLI I just noted above. But the larger the group, the more likely it makes sense that you will need it and want it. All right, what happens when there's a problem? Say that there's a news story that one of your partners has just been indicted for some um, issue related to excess prescribing of narcotics. First thing you do is you call an attorney. Call your attorney. Limit the ability for this individual to either come to the premises or to access the records. You just want to make sure that the record stays clean and there's no behind the scenes mischief going on. You want to freeze prescribing ability, particularly in this case, we're talking about diversion, and put them on the leave policy. As we stated earlier, the bylaws should explain for cause triggers and what the next step would be. So if it turns out there's some horrific crisis, it should already be in the bylaws what the next step should be. It doesn't mean you need to fire them immediately, but it does mean you probably need to limit access and put them on leave, and do an investigation. Just see what the extent of the problem is. You need to do a deeper dive, once you are aware of the problem. And payers and hospitals will probably become aware of this, and you should chat with your attorney. What do I need to notify these entities about? There may be some obligations. In the hospital bylaws may have something in there that says that if a doctor is indicted, for example, that they have an obligation to notify the institution within 72 hours. Some boards of medicine have similar obligations. Some payers have those same obligations. They're all different. There's no single rule out there. I do know that with some boards of medicine, if a doctor is arrested, you've got X number of days to notify that board of the arrest. In other states like California, it's an arrest does not trigger any notification obligation. It's really just the indictment that triggers an obligation. So arrest in and of itself is not the end all and be all. Every state is different, and this can be even more unnerving if you have licenses in multiple states. So if you have a license in one state where you've got a 2-week obligation to notify the licensing board, but no obligation to notify the other state, you can see how this can get complicated very quickly. All right, who do you tell and what do you tell them? You really need to have some chat with the staff. They can read the paper, they can read social media, and you need to keep them in the know. And I don't need you don't need to tell them everything, but you should define your general take on a need to know basis to the staff, what you know and what you don't. Um, Try to avoid speculation, but you're going to need to educate your staff. The last thing you want to do is have your staff believe that they're on a sinking ship and that their best course of action is to leave sooner rather than later. You may very well lose your best people first. And once the best people leave, others will follow. So I think it's important to be able to communicate effectively, but don't do so as speculation. With your patients, communicate to them. Let them know that you are open for business, that their care continues, nothing has changed. Um, Regarding the doctor in the crosshairs, how you're going to manage continuity of care in the interim, that needs to be crisply defined. Talk to your referrals. Let them know what is going on broadly, what you are doing, that this is an isolated event, you are taking action, and that you still appreciate taking care of their patients. Keep them in the know. And for the public, importantly, one spokesperson. You don't want 5 people delivering conflicting messages. It should be crisp, it should be concise, and it should be a single individual, often done with a crisis management organization. These are people that know how to get information out there without lying. You don't want to lie. You don't want to be caught in misstatements, but you want to make sure the least amount is said and that you're not trying to hide or cover up. You want to make sure that just enough information goes out. So here's one script that has been used, particularly with patients. Our practice remains open. Dr. X is on leave. I'll review internal questions. Patient care continues without interruption. That's not the global script and won't address every situation. There may be privacy considerations related to Dr. X, depending upon how and why he's on leave. But this is a script that is 2 lines that lets the public know, lets your patients know that you are open for business and you will continue managing and take care of the patient. Reputation management. Some of the existing patients may post reviews. The public at large may be a cyber mob, depending upon your exposure. And not surprisingly, patients will go onto Google, Yelp, Health Grades, and just talk about what a horrible doctor the person that crosshairs is or was, frequently without having ever been treated by him or her. And so there are ways to manage this. The large review sites will be aware of change. So if the doctor has only received 4 reviews over a year and now has received 180, they will understand that this is likely in relation to a news story, and they will likely just shut it down. But it may take several days for that to happen. We do have a script we have used in the past, particularly when it's a cyber mob, which it's just one sentence saying these are fake reviews that um, and that these are individuals that have never been seen by the practice, and Google has been notified, and you fully expect that these reviews will be taken down, and frequently they are taken down. There is infrastructure with the large review sites to determine what has changed, and they will block this from happening. But you may have to be patient. If you're going to respond, use HIPAA-safe responses. You don't really want to get into the weeds um, disclosing protected health information. If you've already got a problem, you don't want to compound a problem with a second problem. And the other thing you can do is, to the extent you have satisfied and happy patients, deputize them, get them to go online and carry some water for you. Independent validation by your other patients may be useful. You've spent years building goodwill with your patients. If you can tap into them to level the playing field and try and help you manage a crisis, by all means, go ahead and do it. All right, if it looks like you're going to get a divorce, you got to follow the operating agreement and the bylaws and document precisely how and why you're doing it, and then talk about what the divorce looks like. What's going to happen to the medical record and or imaging? What happens to the domain names, email address, non-compete? How are you going to manage that? How do you address notification with the patient and accounting? Um, Sometimes even though the bylaws are quite clear as to what to do, I still think it makes sense to have an exit agreement on the way out the door, which explicitly defines a meeting of the minds. It may reference the operating agreement and the bylaws, but it's if, for example, you really want someone out the door and it's more important they get out the door to not sully the group's reputation, you may be open to the idea of waiving enforcement of the non-compete agreement. You may just say, look, I don't want to turn this into World War III. If this person can get a fresh start and it's down the road, I don't really care. I mean, if they're already dealing with a, a reputational nightmare, um, I think that's one hill you may not want to die on. It's a way to create an exit agreement, try and manage the things that are actually quite important going forward. So in terms of the payers, hospitals, and boards of medicine, I won't get into the weeds on this, but certainly a problem with one individual can create secondary problems with payers, hospitals, and boards of medicine. Just make sure that you understand the scope of the problem, which means looking deep and seeing more broadly what the problem is. You don't want to be surprised by payers coming down the road and then asking for an audit and then asking for a gigantic sum of money. You want to nip this in the bud if you can. So a problem with one doctor can actually trigger your own internal investigation, your own internal auditing to identify what are some of the issues that may need to be addressed and importantly corrected. And if you do that, you certainly may be able to mitigate the damage down the road. All right, so this is more for your use down the road. There are issues you want to address before you get into bed together. There are issues that you manage on the day of a crisis, and then there are things that happen down the road. The most important things that you do are upfront, which is defining the type of group you want to have. What is it that you're going to share? What is it that you're not going to share in terms of assets and liabilities? And make sure you know who's coming into your practice. You want to understand their background, training, and history. What does the data bank say about them? Have they had any issues with the Board of Medicine as well as hospitals? What about lawsuits? What does the public say about them? Often past performance is indicative of future performance, but not always. And I think it's a mechanism to hold a prospective employee's feet to the fire. Are they forthcoming? Are they people who are transparent and have an explanation for any of the blemishes on their record? If you've been out in practice long enough, you will have some warts, but you should be able to explain them away. Nobody goes through an entire lifetime with a perfect record. There's always some patient you wish you had treated differently. There's some lawyer that has sent you a letter. Some patient has complained to the Board of Medicine, somebody who delivered a rotten review online. It's an occupational hazard of the practice of medicine. But if somebody's joining your group, they should explain it to you. I don't think that's unreasonable. The bylaw should define what happens on day one if there's a real problem, what's going to happen next. And then down the road, what do you do? How do you manage a problem employee? Will you separate? Is there remediation? And if so, is an exit agreement or severance agreement something that makes a great deal of sense? All right, so let's sum up. Being part of a group delivers both reward and risk. And you should think about the divorce at the beginning, like a prenuptial agreement. Document the types of things that would trigger a mandatory exit and try and plan for the worst, hope for the best. And when trouble does hit, act quickly, speak with one voice, and make sure your patients are kept front and center. So again, hope for the best, have your attorney draft for the worst. In a perfect world, you'll never need to use your bylaws to manage a problem, but they're there to help you if and when there's a problem. So that's the whirlwind tour of what happens when you have one person in your practice that creates a problem. If you have any questions, please feel free to contact us at info@medicaljustice.com. Again, info@medicaljustice.com. There's a QR code on the bottom right of your screen, which if you click on it, will take you to a scheduling screen for a free 15 to 20-minute consultation related to a medical legal conundrum you may have. Again, it's the QR code on the bottom right-hand corner of your screen at www.medicaljustice.com. A free 15 to 20-minute consultation related to a medical legal conundrum that you may have. All right, so we've been at it for 20 years, helping solve medical legal conflicts, challenges with difficult patients, frivolous lawsuits, issues with the Board of Medicine, National Practitioner Data Bank, employer-employee problems, sham peer review. The list goes on and on. We are here for you, medicaljustice.com. Thanks for listening. We'll catch you next time.